Welcome to the Case Autopsy, the Verdict and Settlement podcast with your host, Mike Campbell. Case Autopsy is part of the family of podcasts brought to you by Lawyer Minds. In this podcast, we explore recent verdicts and settlements from around the country to try and distill down the best techniques for you to apply in your cases. Here's your hosts, Mike Campbell and Chris Finney.
Today we have Matt Nakajima and Lindsay Lawrence from Ritker's and Ritker's in Ohio. And I've known Matt, I don't know, for a few years now. You know him, Mike, from some of the seminars we've been to. And really excited to talk to both of them today for a couple reasons. Number one, Matt has established a reputation that he's building on of taking tough cases. I mean, very tough cases, tough liability cases, and producing very high verdicts. And so we want to talk to him about that stuff. And then Lindsay helped him. They co-tried this case recently where they had a $800,000 plus verdict, a pedestrian case, where
during COVID.
During COVID, and I saw some snippets of the trial, and it was pretty interesting. The courtroom, it looked like Matt was standing there by himself, but this was a homeless lady, I believe, where they came in late into the case, and defense kind of, discounted their client because of who she was in her circumstance in life, and kind of defined her as that way. And knowing how they try cases at the Ritker's law firm, I'm not surprised at the verdict from them, but it's a monster verdict based on the facts of that case. So after talking with Matt so many times, we're like, hey, let's get on here. Let's selfishly, like me and you do, Mike, let's get into this. Let's find out what worked, what the thought process was, so that you and I can steal it, but also so that other people can learn from it and kind of use it to help their clients in the best way.
Absolutely. And I think that these guys, like you said, they take on tough liability cases, and they do really good job with them. And I'm just excited to hear from them today. And I think let's just jump right in.
You're listening to the Case Autopsy, the Verdict and Settlement podcast. Here's your hosts, Mike Campbell and Chris Finney.
So Matt, let's start with you. First, give us the case name.
The case was Nikki Poteet versus Gene McMillan.
Okay, and was this a Kentucky case or a Ohio case?
It was an Ohio case. Obviously, Lindsay and I practice on both sides of the river, being in the tri-state, with also Indiana. But this case was in Warren County, Ohio. One of the single most conservative venues in Ohio. It went for about 70% Trump, irrespective of political, affiliation. But it is generally not a place that trial lawyers in our region want to be.
So how did you guys find your way to be in the trial lawyers for the trial counsel for this case?
Well, we were frankly lucky that Nikki had prior counsel. They actually did a good job doing the best they could to work the case up. There were very difficult facts. Liability was being disputed at the time. And the reason for that is Nikki had intravenously taken meth the evening before the crash. Meth can stay in your system for purposes of impairment up to 14 to 24 hours.
Gotcha.
And
so we can set it. You guys, when did you come into the case?
We came in 11 days before the trial was set to go. We filed a motion for continuance, and frankly did not think we were going to get it granted. We had a judge that I feel confident in saying he saw the injustice going on, and he gave us a brief continuance to retake some depositions and to open up discovery briefly. And that's what we did. So we ended up trying the case, I'd say 5 to 6 months after it was originally scheduled to go to trial.
But discovery had pretty much closed, but you were able to open up some things and retake some depots.
Yes.
Yeah. And I assume the defense contested that.
Yeah, they fought us on it. And we were luckily, because of the fact that we were able to open up discovery, we actually found $1 million umbrella that they'd never disclosed during the 3 years beforehand.
Oh,
Gotcha.
that's a fun fact to find, right?
Yeah.
Pretty big fact to leave out. Lindsay actually took the treating surgeon's deposition.
Had the prior lawyers taken the treating surgeon's deposition, Lindsay?
There was one discovery deposition taken of the treating physician, and so then we asked defense counsel to not retake it, but to do a trial depo for purposes of showing the evidence and the testimony to the jury.
And in Ohio, do you guys have evidentiary and trial depots? Like in Illinois, you kind of have that, but in Missouri, we don't have that. So can you explain that a little, Lindsay?
Sure. So in Ohio, you can do your general discovery depositions where they're kind of broad depositions where you're trying to figure out what the witness knows. But in this case, we did a specific, what's called a trial deposition of Dr. Venkatariappa, who's the treating physician of our client. And so with the trial deposition, the purpose of that was essentially you're questioning the witness as if he's on the witness stand. And you're moving in evidence and you're going through things with him in a very concise and clean-cut manner in a best way to convey that evidence and information to the jury. And so with the trial deposition, it's a little bit more formal in that you're a little bit more hesitant about objecting because you don't want to be overly objecting in a trial deposition when it's going to be played to the jury. And it's a little bit more formal in that you kind of have to have a clear-cut outline of where you're going with the witness and what you need to get from the witness so that the jury understands why that person's there and the importance of their testimony.
And this was the surgeon?
Yes, so he was the second surgeon that came in and he did the internal fixation device on our client's ankle and leg. And so she had two surgeries. It was a 2-phase surgical process, and he was the second surgeon that saw her, but he ended up being the physician that provided care and treatment to her for, so many months after the surgery and did her follow-up treatment.
So when you did the deposition, did you use any visual aids to show the jury?
Yes. So Matt and I met and we figured out what visual aids that we wanted to use. If we had pictures of our client or x-rays, we had those blown up, and then we took something with us so that we could prop up the blow up so that when we were questioning the physician that the camera was angled just on him with the exhibit. And then we also had an actual skeleton model of the lower leg and the ankle. And then we had him go through and start off with identifying the bones of the leg in general, and what portions of her leg were injured as a result of being hit by the car.
So in terms of how long was the depo itself, and then how long was the trial depo that you actually played, if there's a difference?
Well, there actually was a big difference. And so the trial deposition itself, without being played to the jury, was probably about 3.5 hours. So I think I went maybe 2 hours on direct with him. And then the defense counsel's cross was maybe about an hour. But then a majority of defense counsel's cross, we ended up redacting and have had it taken out. We got a ruling from the court to exclude so much evidence because the main defense in the case was essentially, in more words than not, it was basically she's not worthy of being compensated because of all these bad things she's done previously.
She's a drug addict. She's on meth. She's homeless. Yeah.
She's a bad person. She got hurt, but because she's a
Right.
bad person, she didn't hurt like the rest of us.
And they try to slop it in with the treating surgeon.
Right, and so the main cross of the defense lawyer with the treating physician was, well, she didn't go to physical therapy, and then all of these other times she went to see you in your office, it was because she injured her leg at a different part in time, and She did all these drugs. And so we had everything regarding drug use and drug seeking behavior excluded. And so what we did was we went through and extracted those portions of the testimony. And we had a meeting between defense counsel and our side with the judge and went through a paper copy of the trial deposition and went through line by line and figured out what testimony was allowed in, what testimony wasn't. And that, at the end of the day, was helpful because we were able to condense the trial testimony down so that the jury wasn't sitting there for hours on end listening to a video being played on them.
How long was that video that you ended up playing at trial?
I think it was a little under 2 hours.
Oh, okay. So it was still a decent amount of time.
Mm-hmm.
Yeah.
I mean, like, are you guys watching the jury as they're watching the video? And if so, what were some of your gut feelings at the time when they're watching it and you're an hour and 15 minutes in?
Mm-hmm.
So I guess I'll start. So I
like asking the how am I supposed to do this later on, and how am I supposed to feel later on question.
Well, for me, I was sitting closest to the jury, and so there was a plastic screen between Matt and I, but there wasn't anything between us lawyers and the jury box. And then all of the jurors were socially distanced. There was no plastic shielding in between jurors. In Hamilton County and Cincinnati, some courtrooms are set up like that. It's very sanitary, and there's a lot of dividers up. And so with this jury, they were just socially distanced. There was no plastic shielding between them. But the difficult thing was we had some women on the jury that wore eyeglasses. Then they had their mask on, and some of them had heavy bangs with their hair. And
you could not see who they were. Yeah, you literally couldn't see them at all. Yeah. And
so you really just relied on if somebody were to do like a shaking of the head, whether it be yes or no, or nodding in agreement type thing. And then, but it was very difficult to get a read of the jury, and especially the women, for what, how their hair and their eyeglasses were. But we would look over, but I tried not to look over too much because I didn't want them to think that we were worried about, the testimony or.
Well, let's talk a little bit about that COVID protocol stuff that they had in Warren County. Are attorneys masked at all time?
They weren't. We had to wear masks anytime we were at the podium. As long as you were at the podium or close to the podium, you could take your mask off. As well as witnesses, they could take their masks off.
Gotcha. And when you say there's plastic dividers there, Matt, like, how do you guys, I'm thinking just logistically, how do you share notes if there's a plastic divider? How are you whispering to each other? I mean, that's kind of obtrusive.
You have to scoot your chair back and go around the big guy.
Gotcha. So everybody knows when you are trying to share notes. Gotcha.
There's no subtle way to do it. That is correct.
Well, I think I noticed on the last day of trial, there was a little cutout hole in the piece of plastic. But I mean, you would have to be like, maneuvering your way to get your hand under the piece of plastic to get a note over. And so it was just easier.
How many? Go ahead.
I was just going to say, but both sides, I think, I didn't feel awkward doing that because that was just what we needed to do, and defense was doing it, and it was fine.
And that's like my follow-up question for you guys on that is, I don't know how many jurors you had called, but however many you had called, and then what were their general responses to, hey, when you're in the selection, we're going to be wearing masks, stuff like that. Do they care, or do they just say, hey, this is part of the deal, we accept this? Matt, tell us kind of what was the feel from the jury pool upon questioning, and if you got a jury questionnaire before, any kind of stuff like that.
That's a good question. And that's, a lot of people have asked us that. Warren County, we knew in advance because our partner Charlie Vickers had tried a criminal case a few months earlier. They do a lot of heavy screening before the panel even comes. Gotcha. So we know how people feel about COVID even before they even show up, and they're heavily screened. So from listening to Charlie, a lot of the more, I guess, on paper jurors that you would think might be more favorable to you in a civil jury trial, they did not feel comfortable sitting during COVID. And so we knew that going in. We knew that we were going to have a strongly conservative jury pool, and we did not spend time. Now, we obviously asked them for permission before we take off our masks. We make sure that we have permission from the jury before we do anything. So when we get up and we're speaking in voir dire, we say, is it okay if we take this mask off?
Yeah.
And so if someone says no, we wouldn't, but everyone agreed, sure, please do.
Yeah.
We did not spend a lot of time, actually any time, talking about people's feelings sitting on a jury during COVID.
Yeah, that's so. Why not? That's what I'm thinking. Like, you get all this information already before you talk to Charlie, who's a very accomplished criminal lawyer, and you say, you make a decision somehow. I'm not going to spend a whole lot of time on it. What's the thought process behind it?
Well, it's twofold. First, we already know that they're comfortable sitting on that jury because they passed the screening protocols. Second, the judge did not give us a hard time limit. Last time I tried a case in there, I got 20 minutes for the jury. Charlie tried a murder trial that had a mandatory life in prison. He was given an hour. So you do not get much time if the judge thinks that you are being repetitive, duplicative, or just not being very responsive with the jury. He'll cut you off. What we did spend time doing is one of our themes throughout the trial, in fact, one of the biggest themes, was that our client was in prison, by her pain. They had taken away her freedom, her liberty. So we spent a lot of time, as you know, Chris, and what you do in some of your trials, that was our theme, that she had her freedom taken away. So we did spend time talking with jurors about the social restraints, being forced to wear masks, being forced to have a curfew, and how they felt. And we had jurors talking about the loss of freedom, the loss of their liberty. And so that is what we tied into COVID in a manner that we thought jurors could relate to.
Gotcha. Did you start with that in your voir dire, or when did you, how long did you go for, number one, in your selection?
Well, we split it in two. I did the initial voir dire, and then once the alternates came in, Lindsay took over.
Okay.
I would say I went for probably 45 minutes to roughly 45 minutes. I almost always start, and we did the same in this case. I start with the money, how people feel about pain and suffering cases, people suing, greedy trial lawyers. That's usually where we start because people are more responsive.
What was their responses now in the COVID age with that type of stuff versus maybe what you used to get pre-COVID? Were the responses still the same, or was there a variation? Like, me and Mike got a trial coming up in 3 weeks, so we're in a conservative area, so we're interested.
You just go ahead and give us the answer.
Exactly.
Well, we did not. I do believe that jurors are more sympathetic or empathetic to what people are going through. I think we've all been through isolation. We all know now what it's like to have certain things taken away from us on a grand scale. In our case, I emulate Nick Rabbit.
Trial by human stuff. You like, we've talked about that many times before. Yeah, that's comfortable. You're comfortable wearing that style.
And it resonates with me. In this situation, I did the, would you please talk to me?
Brutal honesty.
Yeah, and we're trying to start a cadence here where it's quite clear that I'm just going to stand here in front of everybody, nervous and afraid, until someone comes to save me. Well, the judge would cut me off and say, we're not doing that.
Yeah, because did you feel that pressure where if I don't elicit responses, he's going to be up my, he's going to be on me and he's going to ruin my cadence? How are you, that's an internal struggle. Talk us through.
That is what happened. He did interrupt me and say, we're not doing this. And he would hit them with you can be fair and impartial and things like that. But he was trying to be fair. But in his mind, he thought he saw an attorney struggling getting people to talk, when really we're trying to set the tone that, hey, I need you to speak with him.
I see.
That
So
is very interesting. Go ahead,
that's
Mike.
that is
yeah.
really. I've had a judge told me I was doing jury selection wrong on that basis. That I was not asking the fair and impartial questions, and instead I was asking them about anything a lawyer like me could do to change your mind on this issue or something like that. And so you're up there, and he's interjecting, and what's going through your mind, and then what questions are you asking the jury?
Yeah.
Well, I keep going through it. I mean, everybody said after he'd already, he did ask questions before I asked questions.
Okay.
Before Lindsay got to ask questions. And there were jurors that had prior injuries, been involved in prior car crashes. And he immediately started to focus on them before we got to speak and say, hey, in light of your past experience being injured in a car crash, the fact that you were hit by someone who didn't have an insurance, would that impact your ability to be fair and impartial? And they're kind of wavering and saying, well, if I instruct you to be fair and impartial, you will follow my rules. So they already knew, okay.
They're primed. They know what the answer is.
Yeah. So everybody pretty early on was very clear that they could be fair and impartial, that they wouldn't have any problems awarding a large dollar figure for pain and suffering.
And for those who might be listening and don't know what that means is that my experience has been, Matt and Chris, you might have the same experience. When someone starts that trend of I can be fair and impartial, that will come out of the juror's mouth, at the end of any answer they give you, which, hey, can tell me about this pain? Well, I've had this pain for 15 years. And yes, I was thinking about how it might affect me, but I can be fair and impartial.
Yeah. No one gave me a penny for it, but the guy
I can be fair. I can be
screaming
fair
at me. I can be fair and impartial, which I'm thinking of all the things, Matt and Lindsay, that like go through my head when we're picking juries. And I think before you got up, Matt, what was your mindset? Because you had to know some of this stuff wasn't going to go exactly how you wanted it to. The judge is going to interject, or you're going to have that pressure of, get moving, get responses. How are you committed to what you're trying to achieve? How do you maintain that commitment throughout? That's
a good question. One, you have to stick to your game plan. We try not to let the judge interject too much. I mean, if the judge is going to tell me to keep it moving, I'll probably go right back into doing what I was doing until eventually, like, maybe you'll let me keep doing it or I get admonished. But sometimes it's better to ask for forgiveness later and keep going.
Yeah, absolutely.
In our case, we actually had to have a big sidebar right before we started voir dire because he had not ruled on the key motions in limine about drugs and felony convictions. And, we made it very clear. I mean, either you're going to tell us this is out or we have to introduce this right now and figure out how people feel.
Is the jury in there when you had the sidebar? Oh, man. Okay. Lindsay, tell us what. That's not the start you want to have, a big huddle up by the bench that I assume is fairly heated, or at least there's a lot of talking going on.
A lot of emotions.
Yeah.
So when we first walked in, before the case even officially started, we walk in and the entire jury pool is in the courtroom.
Oh.
So the courtroom is a very large courtroom and it has very high ceilings. And so there's probably about 70 to 100 people just socially distanced all around the courtroom, and everybody's wearing masks. And then we tell the bailiff we needed to talk with the judge. And she comes out and she goes, he doesn't want to talk to you guys. And we're like, no, we have to talk to him. So then he comes out and then he's like, listen, this is against the rules. We're not allowed doing sidebars because of COVID. He's like, I'll make this one exception. And we're like, listen, if they're going to bring in drugs, we filed all these motions that the court didn't have time to hear yet. We thought we were going to hear them this morning. If drugs come in, we need to know because we have to be able to voir dire on that. And if not, if she's going to be voir diring the entire time about drugs and meth and all this stuff, we're not going to have a fair shot. And so I think the defense lawyer started off kind of on the wrong foot with the judge by calling our client's substance abuse disorder a poor life decision. To which
at the sidebar?
Yes.
Oh.
Which he responded to her, you tell your client she should have hit somebody else. And so I took that Hugh, and I ran with it anytime we had to argue our motions in limine, because he would, when he's debating on whether or not to let the drugs in, I said, we're going to have jurors on this jury pool that don't realize that this is a substance abuse disorder, and they're going to think it's just another poor life decision, like defense counsel has referenced.
Nice.
And so I took what she said and just shoved it down her throat, because I just thought it made her look just so
It's callous. It looks callous. Yeah. Like, yeah, it's crazy.
Right. And so, but it was, talk about, you think you have a game plan and you go in and you're like, okay, we're going to start off by arguing these. We're going to figure out what's in and what's out in the case. And you walk in, there's 100 people and the judge doesn't want to talk to you. And you've got that large of an issue that needs to be figured out. So we lucked out that he came and we had that sidebar. But
so that's interesting, because I want to talk a little bit more about the mechanics of the voir dire, and we do want to get to the opening and a bunch of stuff, and we're going to try and respect your guys' time. But, Matt, you're coming in to do voir dire. Lindsay, it sounds like you did a lot of the motion practice leading up to it. Is that about accurate? You had prepped the motions in limine and you were arguing them. That's how you guys divided that up, at least the initial aspect. Is that correct?
Right.
Okay. And so, Matt, you're coming in, and it's like just running with it how it goes. You're probably thinking, I may or may not be talking about an enormous issue of methamphetamines intravenously in my client and her felony convictions, or we're just going to skip it. Is that so? Number one, did you have when you do your voir dire, did you have an outline you wanted to go with, or did you have the Raleigh kind of tripwires that you just wanted to hit a few topics and you took some out? Like, what was your thinking that morning when you showed up?
My main thinking in the car ride up, because it's about an hour, 45 minutes to an hour from my house, is the drugs are coming in, the felonies are coming in. This needs to be my main focus, and we're gonna try to bring it in slowly. I don't use an outline for anything, opening, closing, picking the jury. I will if I have to. I try to have it memorized, or at least have flashcards. What we do is we had topics, like the Keith Mitnick topics on flashcards. So we probably had 12 things. We had how people feel about lawsuits and attorneys that bring them. Second topic was money for pain and suffering. The difference between economic and non-economic damages. And then, we spent time making it clear to the jury, they are the appraisers of damages. You are not to consider who pays this, if it gets paid. The judge enters the judgment. You here are to appraise.
Yeah.
And, you can't consider anything outside the evidence. And so you might have sympathy. Then we talked about, when we get into economics and non-economic, we weigh the economic damages. That's something we consistently do. I know that Chris, you're a proponent of that too.
Yeah.
We did not want to low anchor. Also in Ohio, both the billed and the paid amount come in. So we weighed about 140 in billed medicals. I think the paid was about 30 something. And there was also a future surgery at issue, and we didn't want to fight over whether it cost 80 or 20.
Yep.
Because that's not even why we're here.
That's
we're
right.
here for the human losses.
Yeah.
So once we go through who has a problem giving money for pain and suffering, the human losses, the loss of enjoyment of life, loss of mobility, the loss of dignity, the loss of freedom. That's then when we will transition into the burden of proof.
And are you, it sounds like you're kind of channeling Rowley and Mitnick at the same time. And it kind of like you're using Rowley, but then when you think that juror's going to the wrong end, you then pull out some Mitnick to kind of cause them. If it's kind of a judgment call. Is that right?
That's correct. I tend to lean towards a more of a we're here to build a tribe. Mm-hmm. There are 8 people that can make this team here. Some people are going to have to be cut. I hope you all make it. I hope everyone makes it. But unfortunately, only 8 spots are available with one alternate. That is something that has resonated with me more than immediately trying to do challenges for cause out of the gate and making it very clear early on what we're trying to do, who we're trying to get rid of. Because in many situations in Ohio, at least in my experience, you do your challenges for cause in preemptories in open court. You don't go to the sidebar. So
you're just like, Judge, can this person be excused?
Yes.
Okay. Oh,
And
wow.
are you doing them at the time you believe you've caused them, or is it at the end of the selection? Is it because we have some judges in Missouri that be like, you think number 54's got to go? You tell me right now why he's no good or whatever, and you're like, can we talk on the side here just for a second? But,
I'm trying to do something here.
yeah, but that's not happening. This is open court as you're picking, essentially.
Yes, we did not really get anybody for a cause. Everybody said, they wanted to be a part of this case. They had no problem with it. Another voir dire topic is how important this decision is. Outside of the decision for your family or yourself, this is probably going to be the biggest decision you're ever going to make for somebody.
Mm-hmm.
And I would be remiss if I didn't own the fact that we are saying this because we want people to be on this jury. And we want to make it quite clear that if you want an important verdict, if you want to be part of something special, you kind of need to find from my client.
Are you communicating this to the jury as you go? The 8 men or 8 women or 8 people on the team, and then also we want you to be on the jury.
I don't know if we said that specifically,
but it's the philosophy, and it's sort of bleeding through how it's something you believe in your bones.
Yes.
And so it's obviously coming through. Is that fair?
Yeah, we try to wear it on our sleeve. That is what we want.
Okay.
Usually the challenges for cause come early on about the money. I think we might have gotten this from Chris. I always start out, and I think we said if this was a breach of contract case, would anybody here have a problem awarding $20 million for a breach of contract between a construction company and a bank?
It's a smart question.
Well, no, that wasn't me. That was actually Randy McGinn who gave us that. And at an ethos type deal I was at with Rick Friedman, she spoke, and she's a trial lawyer out in New Mexico, and she had that breach of contract deal. And I liked it. We've used it. Matt's used it, obviously, to great success. And I think it does put kind of in perspective for the jurors what they're supposed to consider and how it applies and everything. And it's very clinical for what, I don't want to judge jurors, but for the conservative minded jurors, they have no problem giving those damages to a breach of contract. It's where you're trying to get them to bring it over to the PI case, which they have an issue. It's not really natural to them. So seems like it's the right path in Warren County. Is that typically you found that to be productive, Matt, using that line of questioning?
I have, and it's something I've incorporated into all my voir dires now. And then we transitioned into, well, if this was a hypothetical case, not necessarily this case, but let's assume that you are on a jury and you're back in that jury room, and everyone objectively believes that the human losses, the pain and suffering, the loss of enjoyment of life is worth $20 million. Objectively, that's what it's worth. Will anybody here have a problem for whatever reason, political, philosophical? You just don't want to be associated with a verdict that large to where you say, hey, even if the evidence supports it, I can't sign my name to this. We usually get a bunch of people for a cause on that. In this situation, it worried us.
You got none. You thought.
They're like, oh, we'll do that. We'll give $20 million.
Well, I've been there, and were you like, man, I didn't ask that right. I did something wrong. Like Lindsay,
they're not. No, you're not getting what I'm trying to ask you. Which of you don't want to be on the jury? Yeah.
So I think at one point Matt said, "Oh, well, we're after so much time." I think he said something like, "Oh, well, we're not going to be asking for $20 million." And a couple of the jurors laughed. And this was after everybody was like, "We're pretty much ready to go." And I thought, is that a good laugh or is it a bad laugh? So you just, but
sounds like a good laugh. Yeah.
Yeah.
It turned out to be.
Yeah. But I think Matt did a really good job of setting the tone of the importance of the money, and that this is going to be an important case because we really need people to fairly evaluate this. And, this is a high value case.
And you're creating that sense of awe, this is a big deal. We're in a courtroom during and when the jurors, Pat Malone has talked about this, when they get in a sense of awe, they can make these incredible decisions that are very kind of altruistic. And I want to ask you, Lindsay, I know I've talked to Matt a lot about some of these techniques, when you had been in trial prior to this one, have you utilized these techniques, or was this new for you trying this case with Matt on some of the trial by human type stuff?
So this was new for me in regard to the voir dire aspect with Matt, talking about the lifelines and wanting people to talk to him and setting that cadence. For me, that as a lawyer, because I do more med mal type cases than personal injury. So for me as a lawyer, that just wasn't in my personality type to do that with a jury. And so I think I was a little bit more structured in my approach with them. But it was definitely a good learning experience because I saw how receptive the jury was at points in time when we were talking to them. And then also I think it was good to see the judge trying to interject and limit things, because you're trying to read the jury and you're reading the judge. So, but I definitely learned a lot. And I think from the human losses and setting the tone, the value high, and setting that number high at 20 million, I think every lawyer should be doing that in voir dire from the outset.
So Matt, I know that we talked about this, but I want to kind of go back to, you're up there asking questions. You're trying to build, some camaraderie with the jurors, and you're wanting to get them to engage with you, and the judges, in good faith, apparently thwarting that. What's going through your head at that point in time? What are you feeling? Because I got to be honest with you, when you were talking about earlier, I got really anxious because I've had that experience a couple times. And so what are you saying? Let's go to a psychological safe space. You having that debate in your head, or what are you thinking?
Those are natural things. It's, I watched a George St. Pierre interview, this MMA fighter.
Yeah. GSP.
And he was talking about how nervous he gets before every big fight. And once the fight starts, then it's on, but it's that walking in, he's nervous as can be. I'm the same way. I wear my heart on my sleeve. I get very anxious in preparation for it. But once you get in there, it's like a fist fight. And we're trying to win this. And whether you're getting punched from over here, you have to continue to stay focused and take the fight that's in front of you. When the judge kept interjecting, it impacted the cadence. There's no two ways about it, because I'm trying to ask open-ended questions here. I used to do a lot of inoculation questions, and I don't do that anymore, because I don't want the jury just to say yes or no to what I'm saying. I want to know what they truly feel. So I thought I was worried for a moment that's where I was going to have to go. Like, can everyone agree to do X, Y, Z, as opposed to, how do you feel about these things? Some people feel this way, some people feel that way, and it's all right. I just need to know how you feel. So that's kind of the direction where I felt like the judge wanted me to go. That's what defense counsel did. You will get receptive answers. People will say, sure, we can do this, or no, we can't do that.
It's familiar. It's familiar and it's safe, right?
Yeah. But it doesn't give you any kind of understanding about who they are.
Exactly. And so we're trying to flush out, and unfortunately, we never got that one juror to say, which I'm sure they had those feelings. And by the way, we could only speak to who was in the box.
Sometimes they cycle them in.
Yeah.
So for your cause strikes, if number 7 in the box, you think they need to be struck for cause, you make that motion in open court, judge makes a decision, and you replace number 7.
Exactly.
Gotcha.
But we don't know who's next.
Oh, you don't know who's next in the so is anybody sitting out there listening to the questions?
Yes. So the panel everyone in the panel can hear, but they don't have a line. So in Kentucky, there's a line up, and you kind of know who's next. Same thing in Cincinnati. You know who the next person up is. Over here, it was like juror 346.
Pops up from the back row and walks on up. Gotcha.
So you don't know if you use a peremptory or a challenge for cause, whether the person next up is going to be better or worse.
Wow. That's all right. Let's.
That's rough.
That's rough. All right. Let's move. I would like, because we could spend actually the whole show talking about more dire, but I wanted to cover a couple other topics, which I think Mike and I have seen in the last few years. I know that you guys have seen this, Matt, and I think you have, Lindsay, is the team approach to trying a case. You know, no longer are we seeing where it's the solo who shows up with his briefcase and his client and wants to kind of evoke some kind of sympathy or underdog feeling from the jurors, that I'm here by myself and the defense is over there with all those people. What's your guys' feeling on trying cases in teams versus trying solo? And, what do you think the benefits are, and if there are any drawbacks?
Sure, I'll start. I think there's no downside to trying a case as a team. I think it alleviates the pressure for each individual attorney to have somebody else. And I think it's good to have an extra set of eyes and ears in the courtroom to have somebody else, interpret how the judge, read the jury, read the judge. And I don't care if it's a 2-day trial, if it's a 2-week trial, I still think that every lawyer can benefit by having more than just one single person trying the case. And I think also the client appreciates it too at the end of the day.
How did you guys make your decisions on who was going to do what?
I feel like we were both fairly, I don't know if you call it laid back. I mean, Matt, it was more Matt's case. And then he said, do you want to help me try the case? He said, yeah, let's go do it. And I said, what do you want me to do? I said, you tell me what you need me to do. I will do anything and everything. Just tell me, and I'm happy to do it. And we sat down one day and figured out, okay, what's our order of proof? Who's being called on what days? What videos are we playing? Who do we need to call as fact witnesses? And we just kind of went through and broke everything up and then just went head on with prep and getting the case ready.
Gotcha. Go ahead, Matt. Yeah.
Well, and to be clear on this, it's Lindsay's an accomplished lawyer. She's surgical with doctor depositions. I mean, this is somebody who, I don't know if her dad is Dick Lawrence, former inner circle.
Okay.
So I mean,
Lindsay knows medicine. She knows how to do this stuff. You don't have, just she'll dice it up any way you want it.
So she's phenomenal to have come in and do doctor depots because her medical acumen, I mean, it's through the roof. So she has that built-in knowledge base, that subject matter knowledge that frankly, I have to spend a lot of time studying to learn. So, if you're going to get someone of Lindsay's caliber as opposed to, a first-year associate, I'm not going to ask her to come and try this case with me and just be a second set of eyes. She has something really to bring to the table. So we split up the experts, we split up closing, and we split up the fact witnesses.
Gotcha.
Now, that's a tremendous relief for me when you have skilled, co-lead counsel who can come in here and take some of that stress off. I mean, because it's always stressful.
You just get to set it and forget it. Like if I assume Lindsay, was there a defense medical expert?
Yes.
And did you cross them?
Matt actually did that depo.
Really?
We did all of the experts. We did all of them as trial depots. So they were all videotaped and pre-recorded to play to the jury.
Okay. And did you explain that to the jurors that, hey, we did everybody, ahead of time. It's safer for COVID, all that type of stuff. Is that what you said, or how'd you handle that with them?
I think we really explained it as we did these ahead of time and that they're not able to come testify live in court because they're treating patients and they're currently practicing physicians. We really tried to stay away from, let's remind everybody that there's this global pandemic.
Gotcha.
Mm-hmm.
And it was strategic as well. I want to put that out there. One, the treating doctor would not show up live. In fact, he wore a mask even with a thick Indian accent through the video demo. So, but in addition, anytime, you have a lot of really, really bad facts that the defense is going to introduce through the experts. And it doesn't matter what the answer is. They're going to get into bad facts through their questioning. We strongly recommend doing video trial depositions so that you can actually get that motion in limine to strike line item by question, because they don't care what the answer is. You know, they're going to say, well,
Just
did you know that she did meth 14 hours before the crash? It doesn't matter what the doctor says.
Yeah, it's already out there. So it's that is a good point, because I think people go back and forth on video or no video, but I think video has definite benefits of things exactly like that. It's like, Judge, the lawyer can't testify, and all he's doing is asking questions that have no bearing on this case except to infect the jury with some character evidence that's irrelevant. And it sounds like your judge he had some spine to him, I guess. I was like, we're not going there.
He was a stand-up judge. Now, I think that, as they always argue, well, you know, Judge, at least let us ask the question first so you can rule on whether it's objection. But had we gone live, okay, you know, you could not unring the bell. And she took liberties. There were two defense attorneys. State Farm actually paid for 2 trial counsel, which is rare on a case that they claim is low value. But they continually took liberties. They were asking questions about theft convictions that were absolutely inappropriate, about trespassing charges that, again, the court had already ruled could not be introduced. And it doesn't matter. And so they actually ended up getting admonished by the judge in front of the jury for breaking our agreement as to what could be introduced in regards to criminal history.
So when that happens, are you the one that's jumping up and saying objection, or are you letting the judge arrive at that sort of at that point of admonishment?
Well, I think Lindsay and I were both looking at each other when this is going on. We try not to make objections to the trial.
Sure, that's where I was trying to get to. Yeah.
And we allowed them to go farther because A, we want admonishment. We want to force this judge to do something. And B, you want to see if your client, we'd spent a lot of time prepping her. Okay. We'd had Charlie Rickers come in and cross-examine her very aggressively multiple times. So we were hoping she could stand up on her own too, but it got to the point where it wasn't just one quick question moving on. She was going to go through every conviction until we said something. So we let it happen about 3-4 times, and then we made this big objection, demanding a sidebar. Then, so that the judge, he was pissed, but we let it go to the point where he's going to have to make a really big decision here. Is he going to hold them accountable in front of the jury, declare a mistrial? Or is he just going to let this go and there's no real in between?
And did you request a mistrial when they got into that stuff? You made the decision, like, Lindsay, what was it? Yeah. I mean,
well, we had debated it and we had gone back and forth because we were just so just mad at the defense lawyer for doing
it's bullshit. Yeah. I mean, it's like everybody hates that stuff. It's underhanded. And it was like we were all on the same page. And they knew we were on the same page and they ambushed us.
Bush League, yeah.
The night before, we had stayed in court, I mean, probably close till 9 o'clock at night, figuring out all of these issues and figuring out what was in, what wasn't, what they could go into. And we agreed with the judge, okay, you can ask about this one charge. And so then the defense lawyer starts going in all these other, subsequent charges. And I could tell the judge was getting really upset with her. And then we had a juror who was born in Scotland, who, when I looked over, he was shaking his head at her in disappointment. And then, so I thought, okay, we might have the jury a little bit on our side. And then when we went to have that sidebar, and then the judge gave the curative instruction, I think the jury realized at that point in time, like, that she really should not have been doing that, and that's not why we're here. But at that point, we just thought, you know what, we're already here. Let's just take it. I think we're going to do okay. The jury, I think, is with us because they were upset that she had done that.
You could feel that. Yeah. You could feel that anger from the jury.
I could, at least with one of them.
Yeah. That's a powerful feeling, and that relationship is established in your jury selection. You know what I mean, right? Don't you did you guys felt, all right, we know these people pretty well, and then you start feeling them in the box, and you're like, they're not digging this. Like, they know this is Bush League. That's an interesting dynamic right in the middle of trial that anyone who's tried cases knows. I have a record. if this doesn't go my way, I need to like preserve it. But what if he grants it? And then we had the jury, like there are so many thoughts at that sidebar that are going through your head within 15 seconds. Like, what do you guys, was there any regret, or was it just like, we made our decision, let's stick with it, the judge admonished, let's move forward?
I think even though I saw the one juror who was upset, we still had serious concerns as to, okay, there's no one ringing the bell. What do we do? Yeah. So, I mean, it wasn't just like a quick, let's just move on. It was like, has the whole case now gone in the trash can because of this?
Yeah.
And so it was a very, I think it was a very difficult thing to decide on. And then I think also, I think we really thought long and hard about the mistrial, because we thought, okay, how is this going to impact our client if we move for a mistrial and then have to wait so much more time to have her day in court? Because even if it moved for a mistrial, I don't think State Farm would have offered any more money on the case.
Yeah.
And so, I think Matt and I really took a huge risk with continuing on with the case, and just hoping that the jury was really not going to take that into consideration.
I got to know, who did opening, who did closing? Was that something that you guys divided up, or was it something that, Matt did or Lindsay did?
We divided it up. I did opening.
Okay.
And we actually split closing in two. I don't know how it is in Missouri. In Kentucky, you just go last. The plaintiff goes last.
Okay.
In Ohio, we get our initial opening.
Yeah, rebuttal.
I mean, gets their closing, and then we get rebuttal. So Lindsay did the rebuttal. She brought it home.
So what was a factor in you doing the opening, or why did you want to do the opening versus the closing? I mean, what kind of factors? And also the fact witnesses. What was your feeling in dividing those up? Was there much thought in that, or did you just feel more comfortable with one over the other?
Kind of just the way it happened. I mean,
sure.
It wasn't. I think it's hard anytime you've had a case for any period of time to give things up. I felt close to the case and wanted to do opening, but at the same time, I mean, Lindsay's not just going to sit here. I mean, she has tremendous talent. So we agreed, hey, I thought about it, and I said, if you're going to come in here, you need to do something significant. And so I wanted you to bring it home, and she did a great job.
Here's why I was asking that.
Yeah, she'll put some serious skin in that game, rather than just, like you said, being a second chair. I need more than an extra set of eyes. I want to be, if we have a call at 2 a.m., I want you invested in the call.
You're on it, yeah.
And I think also the jury wants to hear from both of you. If you've got two lawyers sitting at the table, I think.
What's going on with this other person?
Yeah.
Right. And I think especially with us being a male-female dynamic, I think some of the jurors, especially being women, maybe would have arguably gotten put off if they're not going to hear from me. And, that might have affected Matt negatively in their eyes. So I think it's good to hear from both.
So my overthinking brain, the reason why I was asking that was because, there's some thought that if you're getting up and doing jury selection and you have that relationship, so that's why you do opening. And then, then I tell myself that if you've established that relationship, maybe they want to hear from you at closing. So that's kind of where I was wanting to, explore if that sort of thinking went into it as well.
Well, and it does. And that's why we knew Lindsay was already going to do the rebuttal close. So that's why she helps pick the jury. So, and that's the same thing that Charlie and I do when we try cases.
Yeah, sure.
If he starts in voir dire, then once he gets a couple for cause, then I will come in and do the rest, or vice versa. Same thing is what we did with Lindsay and I, because what we do not want to do is have her do this big rebuttal close and then not hear from her the entire 2 days. So, that's why we broke it up to where they're hearing from me, they're hearing from Lindsay, they're hearing from Lindsay, they're hearing from me. So there's that continuity.
That voir dire procedure, that's different, where two people are allowed to speak for the same party, is that by rule? How does that work? I mean, you handle one group to seat the jury, and then Lindsay, you can handle the alternates. I mean, talk me through that, because that is different for than what we do in Missouri. Typically, it's just one person speaks for one party.
Generally, that's all I've ever seen in our cases. I will tell you, it happened a long time ago when Charlie and I couldn't agree on who was doing what, and we each wanted to do everything. So we had a compromise, and it's worked ever since, and we've never had an objection. So we'll just split it now.
I like that idea.
You get to know the juror as
from both angles.
Counsel. Yeah.
Yeah. I mean, you get both. And so I'm like really into this idea. So Matt, you get up, you start asking questions for about 45 minutes, and you're like, all right, Judge, I'm going to have a seat. Miss Lawrence is going to come up here and finish it off. And nobody says a word.
We've never had defense counsel object.
And I think, honestly, if defense counsel were to object and be like, she's not allowed to talk, I think they would just
go over well. Yeah.
I mean, how do you, yeah. And the judge was fine with it, so we went with it. I
like that. Mike, we're going to have to try this. We may have to try this out. Don't know if you can do it till you try it.
That's right. And it's a forgiveness rather than, well, we'll see what happens.
Yeah.
But yeah. I mean, that's what I'm thinking is, if I get up and give the opening and the jurors haven't actually heard from me or seen from me, and then they don't hear from Chris until the very end, let's say he's doing closing, I have a fear that they're like, wait, what's going on here? Who's our guide? What is that, I mean, am I overthinking it, or is that something?
I don't know. What do you guys think? I think maybe a touch, but I mean, as long as we're both up there, it does have, we got to play by some of the rules that the court gives us, but what do you guys think?
Well, I like the fact that there's two teachers, there's two
Sure.
basically leaders of this tribe potentially. So if we spoke to the jury afterwards, they all stayed except for one. They wanted to speak with us. I think it worked out really well. I think there were some jurors that resonated more with Lindsay than with me.
Yeah.
And I think it was a real benefit. In fact, there was one juror in particular that said he did not like my open-ended voir dire at all. and he liked Lindsay's more direct approach. Like, this is, how do you feel on this?
Yeah.
So.
Yeah. And see, Chris is someone that I think does a very good job in voir dire. I know my style is more professorial, right? Yeah. And so I get a little nervous about that. And I'm like, I'm just going to let someone else do the voir dire, the jury selection. And that's reassuring to hear. Not saying your approach is professorial, Lindsay, but mine is more of a,
more precise is what we would say, more clinical. You guys are probably more clinical.
Right.
But it just means you and Lindsay, Mike, are smarter than Matt and I. We just kind of are just there to, I don't know, hang out, I guess. All right. So just so I had the facts straight, because I don't even know if we got to the actual facts. This was a homeless individual. I don't know if it was day or night, outside of a crosswalk, inside of a crosswalk, highway, roadway, street, avenue. Run us down the elevator version of the facts of the case.
Well, it was November 15, 2017. It's raining. Our client is walking down the sidewalk. She's walking because she's legally blind. She walks everywhere. And she is passing the entrance to the library. Obviously, to get into the library, the entrance goes over the sidewalk. The defendant was a 74, almost 75-year-old widowed librarian who was making a left turn into the library, did not see our client, never saw her. The first thing she saw is something bounce off the hood of her car onto the grass. And on impact, she shatters our client's ankle joint, the tibia fibia, above the talus that makes up the ankle joint. It was an open fracture, so her tibia was sticking out through her skin. The defendant checked on her briefly, but doesn't recall anything. And we can get into that. They were not able to call the defendant at trial.
So we got so let me get this straight. You have a homeless, and I don't want to discredit this lady, but I want to lay out the facts so we understand. A homeless convicted felon who has a substance abuse disorder, who's blind, who's crossing the street, who gets hit by a 74-year-old widowed librarian.
It's like the sweetest looking person in the world.
And I assume she's driving like a nice old Buick or something. Like she's not driving a sports car. She's driving basically a station wagon. I just assume.
It might have been like a Buick SUV.
It was an
It's a Buick. Yeah.
I mean, these facts are outrageous. This is like insane. And okay, so she can't tell us. So you made some strategic moves. She can't testify at trial because of her lack of recall. She wouldn't have added any probative value to anything, or how did you get her struck from that?
Well, at that point in time, at the time of trial, liability was stipulated to. So we argued to the judge and to the court that there's no reason for her to testify. She doesn't have to give a recall of the facts or what happened because they've already admitted to liability in the case. And, she shouldn't be able to testify to get the jury to be sympathetic towards her because that's not why we're here.
Interesting.
And then we argued that if they were going to allow her to testify, then we were going to bring up when they actually finally decided to stipulate to liability.
We are using this, Mike. We are definitely using this.
Yeah.
For our case. There is no point for anybody that is a great idea. That's a very, I don't want to discredit the idea. It seems so simple, but it's also like really effective. Like, what's the point of this person testifying if it's a waste of time?
And so then was the decision, do we put a case on about liability or do we put a case on about damages? And so is that the decision you had to make, liability and damages, or just damages?
We pushed to get this. Normally we want to bring in the they're fighting liability, but we did everything we could to get them to stipulate to liability and causation, which they actually did. They stipulated that she had some injury from the crash. They wouldn't stipulate as to exactly what, but
once you had
I got it. Like, she had a 4 to 6 week ankle sprain, but it was sticking out of her skin. That was there before she crossed the street. Trust me, folks. Like, that's insane.
Yeah. So we did not, and they still tried to do it. I mean, their whole defense was, we're going to admit liability, but we're going to backdoor the drug use right before the crash.
Oh yeah, sure.
So that was
that has something to do with the bone sticking out of her.
Exactly. So what we try to do when we're deposing the at-fault driver, okay, we always ask them, do you accept responsibility? Do you admit fault? You agree that our client did nothing to cause or contribute to it? That's your final answer. And then, we'll do that at the end, but at the very beginning, we'll go through all the rules of the road, that this would be negligent, and we'll hit them with the mousetrap. And so that's the betrayal we're trying to find, that if they do not accept liability, or if they admit all these facts that would be negligent and then say, yeah, well, I was at fault, but she was also at fault too. That's the betrayal there. And so we try to lock them in on that. And the reason they stipulated liability is because this librarian, who seems so sweet, admits that it would be negligent, admits it would be, an egregious act to hit someone on the sidewalk. She had to yield the right of way. And then we asked her, will you accept full responsibility for this crash? And she's like, no. I'm like, what do you mean? What did my client do to cause or contribute to the crash? And she says, I don't know. I didn't see her until after I hit her. Well, so you agree with me then that you have nothing that you can point to that she did anything wrong to cause or contribute to the crash. And yet you're still not accepting 100% fault. And she's like, correct. So
in the balance of your, not to interject, but in the balance of your strategy here, you're trying to figure out, she's basically saying, I'm not responsible. It must have been your lady's fault. And you're thinking that could be good.
Yes. Right? You're weighing that.
Or do you, not having her testify could also be good?
Well, if it's, the underlying facts about the drugs, okay, if they're disputing liability, I think the drugs can come in.
Okay. So there's something else over here on the balance.
You're trying to keep the drugs out first and foremost. Okay. That's our biggest concern.
Sure.
And so she admits to causation. She admits of something. She admits to liability. We establish in the deposition she has no medical training. Okay. She doesn't recall the conversation with our client after the crash. So now she doesn't have any relevant testimony. The only issue in dispute is damages, and yet she can't give an opinion or any even factual support as to the damages because, one, she doesn't see the bone sticking out of our client. We established that in the deposition. She has no medical training, doesn't recall what she said to our client or what our client said to her. So the only reason you're going to call her is to backdoor the fact that you live on a fixed income. Who do you live with at home? Oh, nobody. Why is that? My husband died a few months ago.
And you work at the library, and it's like, God, that's a great strategic move. That is a very smart move to just take that wind right out of them. They had to not like that.
No.
I mean, what was the response?
For those listening, this grin came on Matt's face. Was
their response just kind of steam out of the ears? Like, Judge, you're not going to let the defendant testify in a car wreck, like where she hit someone? This is ridiculous. And it's like, yeah, that's basically it. And the judge had to appreciate what you were trying to do and understand like the legal theories behind it. And so he said to them, tough luck. What the hell is she going to add?
Yeah, I think he said during the pretrial, he'd never really gotten a motion like this, but he was leaning in our favor, and he told us that.
Mm-hmm.
It's the first time I've ever heard of it.
I think, but wow, it's a simple idea, but it's a great idea. Okay, so that was
very good.
A good strategy. All right, time is getting short, but closing. I do want to ask you guys, what were your techniques? I know you guys had PowerPoints, and I think Matt and Lindsay, we could maybe put those in the show notes at some point. We didn't, technologically we didn't get them set up. It's probably my fault actually, because I rescheduled it. But what was your theme in closing? What kind of storytelling techniques, argument techniques? How did this come together? Like, give us some nuggets.
Well, I guess I can start with the initial, and then Lindsay can go into the rebuttal. Well, we always start out, the reality of it is that we try to address the gravity of what we're asking the jury to do, to come together as members of this community and find in favor of our client. And it's a big decision. It's a huge decision. But when we see them, we see hope. We believe in them. We believe in our jury system. We believe that they are going to follow the law and do the right thing. We then jump into the damages in this case, because that's really what we're here for. And then we put the defendant's arguments in context and go into the jury instructions on the line items for damages. And we did the limo and the briefcase to introduce the damages. But before that, we started talking about, and we had a PowerPoint that went along with it, price tag damages. And just, if this was the Salvador Mundi painted by Da Vinci, and it was burned up, we would know exactly what it costs to repair or to replace. And if you ask some art dealer, well, what's the fair trade value for that? It'd be $450 million. Why? Because it's irreplaceable. It's one of a kind. It's unique. It's made by a master painter. And then we transition into, but Nikki's life was unique. Her mobility was one of a kind. And so we start out by explaining, fair trade value, and we do that some in throughout the case, especially with Deere.
Did you face any objection in your briefcase argument?
No.
Okay.
No, she made no objections, I think, at any point in closing.
She made an objection during my rebuttal.
Okay.
Yeah.
So
what's your time? How much time so the judge gives you how much time for closing?
45 minutes, I think. It was 45 minutes, I think.
Okay. So you did 25 and 20?
I'd say I might have been 30 and Jim Lindsay with 15.
Matt encroached on some time, but so you like briefcase, Matt. I like briefcase, but it helps you lay out chronologically, anyways, mentally, what's happened in the case.
Yeah, exactly. And we focused on what was taken from her, and ultimately it was, and we are going to take away your freedom. You'll never be free, not from pain. It will be stuck to you. It will cling to you. You will be imprisoned by it, but not just for the last 3 years, but for the next 42 years of your life. And, ultimately $4 million is what we asked for. And that's the price of freedom from pain. And then we explained to them that that's what you do. You have to go through each line item of damages. The first one is pain, and come up with a fair trade value for it, not just for the last 3 years, but for the next 42. And you do it for each one. You do it for loss of enjoyment of life. You do it for loss of physical pain, emotional suffering. We had another one. We had loss of
enjoyment of daily activities.
Loss of enjoyment of daily activities, or struggling with daily activities, something along those lines. So we had 4 different categories.
Did you and I should have asked this question before, but when you're talking about some of these damages, did you have before and after witnesses for your client?
We had some.
I don't want to generalize, but I can't imagine they were incredibly powerful. I mean, you have a blind, homeless, I don't want to, speak poorly about this lady, but the facts are she was homeless, she was legally blind, and she had some addiction disorders. You don't want those people coming in, right?
We were very limited as to who we could call. Most of the people in her life that spent time with her close after the crash are recovering addicts or had been in jail throughout most of the litigation. One of our bigger fact witnesses was her brother, and he was incarcerated until about 2 weeks before the trial, and we didn't know if he was going to get out, so he wasn't even listed on the pretrial. Her husband, which had some issues, they'd actually separated. He was actually in jail at the time of trial, so he could not be called. So we were limited to her 2 daughters, and they had a strained relationship because she'd lost them to child services before the crash.
This is incredible. I mean,
it's a tough case, guys.
Yeah, this is a tough case.
Beyond any measure of toughness, this is a tough case. And you guys went in there and.
Well, so Lindsay, what'd you do on rebuttal?
So on rebuttal, defense counsel made a really big deal about the 3 medical doctors that testified in the case, how, everybody who said what, and this person saying this and saying that. And so I tried to just bring it home in that they're really all saying the same thing. And then we had a couple medical professionals, or some of the jury had not siblings, but he had children that were in the medical profession. And so some of the testimony that came out from the treating physician, that because of the internal hardware in our client's leg, she was going to be at a risk for developing infection for the remainder of her life. And so I talked about that and how that's a reality and how that makes the injury permanent and substantial, and how she's at an increased risk for infection. She's at an increased risk for sepsis or for losing her leg and for amputation. And then I really tried to golden rule them with bringing back what we talked about in voir dire. And so I talked to them about how there's things that we all value in our life, and we talked about those things, but then there's things that we take for granted. And so one of the things that I think is fair to say that we take for granted is the ability to walk. And I said, and we know it's something we celebrate because as children and as babies, that is our first moment in life that is celebrated.
That's huge.
Celebrated by the parent, celebrated by the child.
So
and I said, that is the first moment in our lives where we gain independence and we are celebrated as human beings. And so I argued that.
I'll give you guys 10 million. I'll give 20 million, whatever you say. So
well, I argued that to differentiate between, okay, yeah, we all value our health and our families, but we don't value the things we take for granted. And she didn't take her ability to walk for granted. That's what she relied on. That's something she valued. And so I just tried to really put in sympathy about thinking about, their kids. And I mean, I have 2 kids, and you're like, oh my gosh, they took their first steps. Okay, my kid's meeting their milestones. This is a whole, I didn't argue that to the jury, but that was the reason why I brought that up.
They know that. Those jurors know that. I mean, you said it, and I thought immediately of, God, my nephew is walking at 10 months, and the other one's 11 months, and he's not walking yet or whatever, and it's like, everybody wants the other one to walk. It's a big deal. Just do it. That's incredibly powerful. Come back.
I love baseball, and I listen to a lot of baseball on the radio. And when you were making that argument, it's the sound I hear whenever the ball hits the sweet part of the bat, and it's going, and you're like, man, that was
square.
That is square. You don't hear a sound like that very often. When you do, you're like, oh wow, that's really good. I mean, thanks for sharing that, and thanks for communicating that on behalf of your client to the jury.
Yeah, we're gonna steal a lot of this stuff. That I didn't want to that permanent that permanent substantial stuff. That's out of the jury charge in Ohio. Is that what you have to prove?
Yes.
Gotcha.
In order to get above the caps, yes.
Yeah, because you guys have some kind of weird caps unless there's permanency or scarring or whatever the hell it's backwards.
So that's one thing that we really beat home. And in fact, it's from the same place that I met you, Mike, and saw Chris again, was the Ethos Seminar out with Rick Friedman. And Sean Claggett was in my small group, and he'd just literally finished up this med mal trial. Same thing, there was a damage caps issue. Not a whole lot of law on whether certain things can get past the damage caps in Nevada. And ultimately, his case settled before the jury came back. But one thing he told me is, he's like, man, I argued jury nullification as close as I could to that line about why we should get around the caps. And that's what we did. We made it clear, folks, we're asking for $4 million, and here are the damages items in interrogatory number 1. But I want to make one thing very clear to you. No matter what you put down in interrogatory number 1, if you do not check yes to interrogatory number 2, that our client suffered a permanent substantial physical deformity, she will not get justice. Your verdict will not make a difference. We beat that home, that it does not matter what else you have to check this box or we lose.
Gotcha. That's a smart way to go about it. And for those listening in Ohio, the verdict form is called the interrogatories. They're questions to the jurors, right?
Correct.
So, wow. We could go on for a long time. Mike, you got anything else to add?
No, I'm just thinking about that walking.
Yeah.
Celebration of walking, and then, just all of the things that you guys discussed, how I plan to use them in the future. So thanks so much.
But verdict was 800 what?
It was 825,000. And then
Gotcha.
I think we get another 92,000 in prejudgment interest.
So you're over 900 on. What was the initial offer? Was probably a no offer, maybe. But what was the last offer?
110,000.
110, and I bet they were like, "We're giving you a gift at 110." Like, you guys are insane not taking 110. Wow.
Yep.
Well,
good for you guys.
Yeah, that was awesome. It's great to talk with you guys. Selfishly, we took up more of your time than we had promised to take up. But I hope whoever's listening gets at least 10% of what Mike and I have gotten out of this. These are some great arguments, some great strategic approaches. And I'm not surprised. We didn't even talk about Matt's verdict on the slip and fall, where the lady slipped on the wet floor sign that she stepped on.
Next time we got to do this again. This is great lawyering, guys. This is great lawyering all around. Thanks for sharing.
Well, thanks for having both of us. This is a lot of fun.
Yeah, thank you very much. And we'll send you guys the PowerPoints, and if someone could use them on your cast, that'd be great.
Awesome.
You're listening to the Case Autopsy, the Verdict and Settlement podcast. Here's your hosts, Mike Campbell and Chris Finney.
Chris, what do you think?
I mean, the more that thing went on, the more I was like, this result's incredible. I mean, you originally hear like this poor lady with the drugs and stuff like that. No one ever mentioned the individual that hit her was like a 74-year-old widowed librarian, and they left out the blindness of the plaintiff. Right. What they did was 100% top-notch, like expert lawyering, strategy-wise throughout. If somebody doesn't get information that they can use right away from this one, I don't know what, they're not trying cases.
Yeah. And I mean, so a couple things I was thinking about. One of them was there's this movement, I think, with several lawyers. It's a new generation of lawyers that are like, hey, we're not going to take this frame of this is what pain and suffering is worth. And because if this case comes into my office, my frame is an insurance company is never going to buy this,
110 would be a huge offer to take.
I mean, it would be a huge offer. And ultimately what happened was they had a lady who almost lost her leg, may lose her leg, suffered a severe injury, and this is a human loss. And they went in, swung away for her, and they're fighting the battle out on the periphery, while some folks are just like still thinking, I mean, I got to do a 2.5 to 3.5 times calculation on this.
Yeah. That was that really an incredible result, especially during COVID and all that stuff. Those are guys know what they're doing.
I think, we'll have them back on. Yeah. Because there's so much more I wanted to talk about, but I also know, their time is valuable, and so is everybody who's listening. So hopefully, I know we got a lot out of it. I hope that everybody listening did too as well.
That concludes another episode of Case Autopsy, the Verdict and Settlement Podcast. Part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.